Attorney-client privilege is back in the news again as the president, prosecutors, attorneys, and the court wrestle with one lawyer's files. But it's a phrase that is often misused and misunderstood. John Delano, who is also an attorney, takes a closer look at what it means.
Fox talk show host Sean Hannity is blunt.
Michael Cohen never represented me in any legal matter.
Hannity says he never retained attorney Michael Cohen, even as Cohen told a judge in New York that Hannity was his client. Cohen is trying to keep all his communications with his clients, including President Trump, confidential, even though the U.S. attorney in New York suspects a crime.
Confidentiality is sort of the hallmark of attorney-client relationships. We want people to be able to have discussions with lawyers that are kept confidential so that lawyers can give the clients advice.
Attorney Amy Coco specializes in the rules that govern attorneys and their clients and says two rules are frequently confused. One is the rule of confidentiality. Lawyers must keep their clients' secrets.
The confidentiality rule 1.6 applies even if the client is dead or if the client is a former client.
But there are exceptions. If the client lies to the court or his lawyer suspects the client's about to commit a crime. The second rule is the attorney-client privilege, which only a client can assert in a court case.
The client holds the privilege, and the lawyer can't be compelled to testify against the client with respect to the confidential communications.
It's one thing to talk to a lawyer in a law office like this, but to an attorney at a party, at a bar, or over the hedge in your neighborhood. Is your conversation, is your communication privileged? Is it confidential? What happens in that situation? Don't count on confidentiality. The key is whether both parties, not just one, think they are creating an attorney-client relationship.
And it really depends on what's said.
John Delano, KDKA-TV News.